Recording in progress.
Hi everyone, we're just giving a few minutes so everybody will be able to join. There are still people coming in, it just takes a few minutes until Zoom puts everyone who was in the waiting room here. So let's just wait till the numbers are.
Hello and welcome to the Hello and welcome to this LCR Capital Partners webinar. We have some important information to be shared before we start this live webinar. First, we are recording today's session and will make the video available after we are finished. Second, we are planning to take questions as we talk, so please use the Q&A button, not the chat tool, to send us your questions. We will answer questions live or in the same window as we go along. Before we dive in, I do need to make a couple of disclaimers. The EB-5 visa is based on an investment, but this marketing presentation does not constitute offer to sell securities. If you are interested in seeing project investment documents, we ask you to contact LCR directly so we can confirm you are an accredited investor or the equivalent in your market. We can also then focus the conversation on your individual or family needs. And while we will be discussing areas of immigration law, none of the conversation can be considered legal advice. You will need to reach out to your attorney directly and enter a client-attorney relationship to receive legal advice. Please, we understand you are concerned about your individual case, but we cannot answer questions about individual scenarios. Thank you.
Hello, everyone. Welcome to this webinar. It is a pleasure to be here with you. My name is Anna, and I think we have a lot of clients here, so some of you may know me already. This webinar is going to be hosted by Suresh Rajan, our founder and chairman. Suresh, he started his career as a policy advisor to members of the US Congress. After working with the government, Suresh joined McKinsey Company and worked primarily in the areas of strategic development. At LCR, his role is to drive the expansion of LCR's core EB-5 business into new markets, develop adjacent revenue opportunities, and provide strategic leadership across the firm. Suresh, it's a pleasure to have you here with us. I will give you some space to introduce yourself and the company a little bit more, please.
Thank you, Anna. Yes, my name is Suresh Rajan. I'm the founder and executive chairman of LCR Capital Partners. We're a private investment and advisory firm based in Westport, Connecticut. We have nearly 1,000 EB-5 clients from over 30 countries. I can see that many of them are joining us today, and thank you for that. As Anna mentioned, my background has been in politics back in the day. I've maintained a lot of those relationships over the last couple of decades. And that did have me heavily involved during reauthorization, talking to congressmen, senators, and their various staff, along with so many others in the industry advocating for the same. So very happy to be here today to talk with our clients and prospects and my fellow panelists for today's session.
It's also our pleasure to be joined by two leading immigration attorneys. So first, I will introduce Mitchell Wexler. He's a managing partner at Fragomen's Southern Californian office. Mitch represents high net worth foreign nationals, foreign students, startups, mid-cap, and large multinationals in their immigration matters. He specializes in self-sponsoring green card applications in various categories, including extraordinary ability and national interest waivers. Mitch, thank you for joining us today.
My pleasure. Thanks for having me. Would you like me to share some more, or are you going to move on to Brandon?
It's up to you. You can share some more about Fragomen and your work if you wish.
Okay, sure. So Fragomen is it's actually the largest immigration law firm in the world. We have about 5,000 employees across the world and 50 plus offices. And as you mentioned, Anna, I oversee the 3 Southern California offices. And in each of those offices, we have robust EB-5 teams. I've been practicing immigration law for about 36 years or so, including EB-5 at the beginning of that program in 1990. And it's been an interesting ride, an interesting journey over the decades. And I think we're in a really exciting time for EB-5 right now. So I'm looking forward to the next 50 minutes or so.
Thank you very much. And at least, but not less important, we have Brandon Meyer. Brandon is founder and managing partner at Meyer Law Group. His firm is focused on providing immigration legal services to corporations, small businesses, and startups. Brandon is a member of the American Immigration Lawyers Association, Academy of Political Science, British American Business Council, Bay Area Mobility Managers, and Invest in the USA, among other professional organizations. Brandon, again, it's a pleasure to have you here with us.
Thank you, Anna. Thank you, Suresh. And Mitch, happy to do this with you today. A couple additional items I wish to add. So our Meyer Law Group is headquartered in San Francisco, California. We have additional offices in San Diego, California, Charlotte, North Carolina, New York, and Ho Chi Minh City, Vietnam. Like Mitch, I've been in this industry longer than I care to admit. I've really seen the ups and downs associated with the EB-5 over the past 25, 30 years. And like Mitch, I feel that the program is really headed in a positive direction, which we'll spend the next 45 minutes or so discussing.
Thank you so much, Brandon. I would like to reiterate what has been said before. There are a lot of questions to be asked. This is a very important subject that it's happening in the industry right now. We will do our best to answer to all the questions. Please feel free to send your questions to the Q&A tool, but please note that we are not going to give advice to any specific individual cases. Individual cases, you need to speak with your immigration attorney, but we will do our best to answer to all the questions you may have. So not taking any longer with all the presentations, I will give the word to Suresh and we can start this interesting debate.
Perfect. Thank you, Anna. Thank you, Mitch and Brandon, for joining today. I certainly look forward to your advice and counsel going forward. Before we start today's discussion, I wanted to do a brief recap of the last several years. I'll try and do that quickly. The last time the EB-5 program was reauthorized on a multi-year basis was in 2012, when it received a 3-year reauthorization. When that was set to expire in 2015, that began a series of more than 20 short-term renewals over the course of the last 6-7 years. That's a very challenging environment to run a business in. It's a very challenging environment for clients and prospects to consider participating in the EB-5 program without that kind of stability. In 2019, there were fairly dramatic new regulations that were introduced, the first since the program inception in 1990 and 1991. We were then faced with a pandemic that was the first in 100 years, and it's still affecting the globe today. In December of 2020, the EB-5 program was decoupled from 3 other immigration programs that had strong political constituencies, and that left EB-5 very much on a standalone basis, which is not a very comfortable thing to be in Washington, D.C., especially when it's your immigration based. There was the Bearing case, which some of you might recall the name, which was the legal challenge to the new regulations. That was a successful case in the courts, leading to the judicial system striking down those regulations and reverting everything back to prior to November 2019. Then, of course, in June of 2021, a 10-year program reauthorization failed to pass because of one single vote. And that led to more than 8-month-long program lapse. What that yielded really are, global families, the ones that we look to represent and protect, having a lot of questions about the U.S. program, and created a lot of industry confusion. This has been, rather unsettling for all involved. Now, yesterday, President Biden signed into law the Omnibus Spending Bill of 2022. This included the EB-5 Reform and Integrity Act, which reauthorized the program for over 5 years. This is an outcome that LCR welcomes. I know my fellow panelists welcome, and much of the industry. It creates a level of stability of a well-defined and well-regulated program. This is something that's been long in coming, and I think we're very eager to advance the EB-5 program under these new guidelines. There is a lot included in this reauthorization and reform. We are going to tackle, I think, the bigger issues that affect clients and would-be prospects. These include a general EB-5 visa updates as per the new program, regional center reauthorization and reform, and then, of course, timely processing, which has always been a challenge within the industry. The main thing that's changed for an investor's consideration has been the investment level. Since inception, the program had been at a $500,000 level. That hadn't changed until the regulations in November of 2019, which ultimately were struck down. But as of yesterday, the new investment level for the industry, lower level, went from $500,000 to $800,000. These are for targeted employment areas and infrastructure projects and rural projects. And then at the upper investment level, $1 million, $1.05 million for all those outside of those, the TAs, the rules, and infrastructure. Brandon, this might be an easy question, but is this change in investment level an impact to current investors?
No, Suresh, it does not. The new investment levels of $800,000 for projects in target employment areas and $1,050,000 in high employment areas applies only to new EB-5 investors post March 15th, 2022. Investors who got their 526 petitions or any other type of EB-5 petition submitted prior to that date are subject to the EB-5 rules and regulations as of that date.
And what about projects that have TEA statuses that were established years ago? How does the new program affect those?
Fortunately, the same concept applies. As long as the project was in a targeted employment area or TEA at the time the investor submitted their I-526 petition, or at the time that the investor made their investment into the project, whichever occurs first. As long as it was a TEA at that time, the investor will be, if that area subsequently no longer has TEA status, that does not negatively impact the investor.
Terrific. So current investors are in a good position. They're not affected by these changes in TA definitions or how they're defined by DHS. On a go-forward basis, a big change with the new program is that TAs will now be defined by the Department of Homeland Security. This was typically done by individual states, which was the type of oversight wasn't there that Congress wanted. They wanted something more centrally located for definition and application. And that will now be in the hands of the Department of Homeland Security. Mitch, what's the background here? Were there a lot of different interpretations of TEAs, and why do you think this moved in this direction?
Yeah, the whole TEA issue was a bit like the Wild West up until yesterday. It was up to individual states and governors, and the protocol, the methodology that was acceptable to be used by states was very lenient. They were actually permitted to kind of annex 11 or 12 contiguous MSAs, metropolitan statistical areas. So it was a lot of gerrymandering going on, and which resulted in TEA designations for places that you would not think would be a TEA. So now, as you say, the federal agency is now going to oversee that whole operation, and there's 3 different TEA types now. So unemployment, which was vastly the most popular way for a TEA to be designated. If a particular location has unemployment 150% of the national average, and that by far was most TEAs. Rural always existed, but there were far fewer rural TEA projects on the market. We think that's going to change, by the way. And then infrastructure, and we'll probably talk a little bit about the set-asides for those a bit later. But we think rural is going to be the name of the game going forward, only because there's of the 20% set aside for those. So those are going to be the prizes that investors are probably going to be looking for.
That's helpful, Mitch. Before we move to set-asides, and that's obviously a very important category, another question around TAs. What is the impact on existing projects and new projects with the new TEA regulations in place? How do projects need to be dealing with that already have investors in place?
Well, for all new 526s that are going to be filed, which can happen 60 days from yesterday, they're all going to need to comply with the new TEA rules. So regional centers like LCR and the others are going to have to kind of redo and reshuffle some of their offering documents and apply for new TEA designations, which are going to be good for a couple of years. So very doable, but just a lot more paperwork for you guys.
Yes, we're all looking forward to the additional paperwork in this industry. You mentioned set-asides. I think many of us were very pleased to see rural projects get some special attention with the reauthorization with reserve visas. It was, I think, a bit of a surprise to many to see infrastructure projects added as a category. How does Fragment's seen rural visa applications in the past, and do you think that's going to change meaningfully here in the new term, in the near term, with the new program requirements?
Well, as I mentioned, the vast majority of projects that our clients were gravitating to, almost all of them, I'd say 99.5% were in TEAs of one sort or another. And the vast majority of those were unemployment TEAs. There are several good rural projects historically that have been on the market that have attracted some attention Those are going to continue to be popular until they're fully funded. But we really haven't seen a lot of them. But that's where the focus is going to be going forward now.
The set-asides, I think, are capped now at 20% reserved. How does that restriction affect other visa applications, or will it in the near term?
Well, it'll be interesting to see how it plays out. It's kind of a new concept, 10% set aside for infrastructure. We're not sure exactly how that's going to be defined. But having a 20% guarantee set aside on a priority basis in the rural, there's some indication that those adjudications are likely to go a little faster. I think that's going to be a big driver in selecting and looking to select a rural and possibly an infrastructure project. So I think speed is always key and paramount importance to investors. So that's just another driver in that direction.
Yeah, I think it's important to add too that these set aside visas, if they're not all used up in 1 year, the unused number roll over into the next year. So for example, if there's 10,000 EB-5 visas available every year, and let's just say in one particular fiscal year, 1,500 rural visas are issued for people invested in rural projects, then that 500 leftover will roll over into the next year, at which 2,500 of the 10,000 will be available for investors in rural projects. And the same concept for the high unemployment areas and the infrastructure projects as well. So that adds another sort of complexity to EB-5 and visa allocation. And we'll just have to wait and see how it ultimately plays out.
And I think the third year after that one, Brendan, it just spills into the regular bucket.
Correct.
So you have to keep an eye on the math and have your calculator out. Yeah.
So a little bit more clarity on that. Brandon, the spillover into the next year, and Mitch, your point, going into the third year, is that spillover then reduce the overall 10,000, or does this become additive to the annual 10,000 allotted to EB-5?
Neither. It just changes the calculation for how the 10,000 visas in that particular government year are issued. And they won't go above 10,000 visas. In some instances, they have this, I guess, for this year, which is approximately 19,000. That's due to some exigent circumstances. But no, Suresh, the idea is it just changes the formula within the 10,000 for that particular year.
Interesting. That's definitely a big change for the industry. Another significant area of concern for current clients, and very happy to see it being addressed in the new legislation, was this issue of aging out of the children of applicants. The opening section of the law defines exactly when a child stays, quote unquote, under 21 for immigration purposes. Brandon, what's your view of this change? How does it compare to current regulations or ambiguities?
Yeah, thanks, Suresh. I didn't see too much of a change, in my opinion, on that particular age out issue. As Mitchell, and in some ways, the age out issue has more or less been made irrelevant by the new law for reasons that Mitch will explain in a couple of minutes. I think the major change that's beneficial in the age out issue is that for investors who were derivative children who were under 21 at the time that they completed the process and received their conditional permanent residence, but then something happened to the project on a fraudulent basis and they lost their permanent residence as a result of that, they can reapply for EB-5, but still on the basis, as dependents on the basis of being children, even if they're over the age of 21 at the time that this unfortunate episode occurs. That is a very, very helpful benefit to investors going forward. In the past, if something like that happened and the derivative child lost their permanent residence due to some unforeseen problem with the project, they turned 21, then basically they lost their ability to immigrate through EB-5 with their family, and they'd either have to leave the United States or do their own EB-5 to start back from the beginning, or find another immigration option to remain in the US. And, Mitch and I have encountered people who have suffered from that outcome in the past, and it is quite unfortunate. And so the new law takes steps to address that particular problem. And I think the legislators should be applauded for doing so.
That's terrific. Let's talk a little bit more about this adjustment of status. The fact that the legislation makes it clear that EB-5 investors that are currently in the US can file for an adjustment of status or employment authorization, travel docs. That's a significant change. This will certainly impact a lot of our clients that are students on F1 visas or even H-1B visa holders. Mitch, how does this work for them, and what do they need to be thinking about over the course of the next 60 days?
Yeah, this is huge, Suresh. As you say, by definition, an applicant considering taking advantage of this has to physically be in the United States, invalid non-immigrant status. So a couple of scenarios: if their 526 is still pending, just with that receipt, they can file adjustment of status. And importantly, the adjustment of status application package has a few critical components to it. One is an EAD, an employment authorization document, basically a work permit, which is extremely valuable. And another critical component is something called advanced parole, which is international travel privileges while you're in the adjustment of status queue. So if someone is in the United States, even with a pending 526 petition, and they could achieve those two objectives, they're about 95% enjoying the value of a green card. Of course, they don't have the conditional green card. That 2-year clock isn't ticking yet, but they could work anywhere. They can travel in and out of the United States. I want to go back to the types of non-immigrant visas. Generally, it's going to be for the vast majority are going to be here on H-1Bs. Some might be here on Ls, some might be here on Es, other types of more robust non-immigrant visas. Now, we've gotten numerous inquiries, I'm sure Brandon has as well, of clients considering flying in on a B2 visa and the next day filing for adjustment of status. That kind of scenario, even if you're in the United States already with a B, when the president signed it as of yesterday, seek individual legal counsel on that, because there's a concept known as visa fraud that has to really be vetted and discussed with your immigration attorney. We don't want someone quickly to enter Monday as a visitor and apply for a green card Tuesday. Clear visa fraud, and it's easy reason for the application to be denied. Certain situations, it might be safe for a B2 person to do that, but it's generally going to be for Fs, Hs, and a couple of others. But on that note, even an F1, that's what we call a purely non-immigrant visa. It doesn't have this great feature known as dual intent that an H does, that an L does. So someone in the United States on an H or an L can safely kind of toggle back and forth, apply for a green card at the same time, get an extension on their H status, internationally travel very safely. F1 does not have that feature. So there's some timing issues that an F1 considering filing for adjustment of status needs to discuss with their attorney.
Absolutely. So those who are considering entering the US in a B1, B2, or here on an F1, definitely have some important and significant timing and processing issues that they should discuss with counsel prior to moving forward.
Well, it sounds like this could be a phenomenal new optionality for certain investors, current clients and prospects alike. But I think the caution coming from both of you is, don't jump the gun here. Get the right counsel for individual situations and go from there.
And Suresh, another consideration on that is, of course, to be eligible to file adjustment of status, your priority date has to be current. So right now, for example, India EB-5 is wide open. It's current. It's available. That was not the case in the past, and it's not going to be in the case at some point in the future. So for an Indian applicant, especially, it's extremely valuable to be able to file adjustment of status, get that work permit, because even if it then retrogresses, you're still traveling, you're still working, life is good.
You're in the system, and I think it's somewhat ironic too that this concurrent filing for EB-5 process has emerged during the month of March. Why is the month of March significant? This is known as H-1B cap season. This is where all the F1 students and individuals overseas, and I guess TNs, Ls, and some other visa categories are all competing for a total of 85,000 new H-1B visas. So to make a long story short, in about 2.5 weeks, 60 to 65, depending on volume, maybe even 70% of the people who are being entered in the H-1B cap lottery by their companies will receive disappointing news that they have not been selected. And so usually what's happened in the past is F1s that basically are running up on expiration of their student visa status rightly start to panic and want to do EB-5 at that time. Well, prior to that, without the concurrent filing feature, it was the timing in many instances was not right. Now with concurrent filing, if someone has used up all of their so-called optional practical training, does not get selected in the H-1B cap lottery, this concurrent filing is massively beneficial in allowing such people to stay in the US and to resume their job search, not immediately, but sometime in the future once their work permit is approved. Major step forward.
Brandon, given that, it seems like for H-1Bs and F1s, there is just a whole lot of new considerations, potentially new opportunities for them to participate in EB-5 much sooner, much faster. How do you think the industry is going to approach that particular category, the F1 students, H-1Bs, in terms of being targeted really for EB-5 from regional centers out there and developers out in the marketplace? Do you think that's going to be a sea change as quickly as it appears it might be available?
Absolutely, 100%. I mean, the epicenter of the EB-5 investor recruitment market had been shifting somewhat for the past several years away from its traditional overseas focus to in the US. So universities and areas where there was a big high-tech presence. So, Silicon Valley, Austin, Texas, metropolitan New York. I expect that trend to accelerate.
That's been going on for quite some time. It's been a target-rich area. So H-1Bs have been targeted for quite some time, but I agree that's just going to get amped up now.
Mm-hmm. And for regional centers and projects, the issue sometimes with the H-1Bs is that many are funding their EB-5 investment through exercising company stock options. So you talk to a potential investor client one day, and when their company stock is trading really high, and then some world event happens and the market dips 10% over the course of a week, and suddenly there's that volatility associated with that particular market. But yeah, the trend has been accelerating domestically for investor recruitment for some time, and I expect that to accelerate even further.
And for reasons I mentioned a little earlier, those cases can typically be filed sooner, just because it's easier to document the source and the path of those funds if they're just going to peel off a few shares of stock.
Absolutely.
Well, I think we're all excited about figuring out how to take advantage of those new openings within the legislation. Brandon, speaking of how the regional centers are going to pursue this and other things, the reauthorization had a lot of impact on regional centers. A lot of it happens immediately. Some happens over the course of 60 days in different timelines. How do you think existing investors should think about processing times now? Are things going to change immediately? Are they going to change after 60 days? And do you see consular services starting to pick up steam, or will that be a bit of a lagging indicator?
Yeah, so the new law states that implementation begins after 60 days. And so you could read that one of two ways, that USCIS could and may not issue any 526 or 485 approvals until after May 15th, 2022. However, I don't think that's the case. I don't think they'll wait that long. I think we'll start to see activity in pending EB-5s before 60 days. At what volume and at what date, we'll have to wait and see. But USCIS has been waiting for this moment, like the rest of the industry, for some time now. And so I don't expect them to open up the floodgates immediately, but I think we'll see maybe in about 3-4 weeks, we'll start to see some activity trickle out from them and accelerate. Now, in terms of the consular interviews, I had a client check their National Visa Center webpage today to see when they were going to be scheduled for their interview. And NVC has yet to update their system post reauthorization. It's still showing that this particular individual is not eligible for EB-5, which has set them off in a panic. So I think it will probably take the consulates and the National Visa Center more time than USCIS to ramp back up. A couple other factors that you need to keep in mind for the consular interviews is that because of coronavirus the last 2+ years, the consulates have a huge backlog of interviews to go through. And you also have to take into account country conditions as well. Not every country is still fully open, and that impacts US consular services. So bottom line, yeah, we'll see. I think we'll see activity from USCIS sooner rather than later. But on the consular side, I think it'll be a bit more slow going.
Yeah, and consulars have different visa priorities. I mean, they're focusing on student visas and some others. We're not quite sure. There's not as much visibility on the immigrant visa priority system for consulates, so we don't know where EB-5 is going to fall in that food chain, really. But yeah, with coronavirus and just kind of training up and getting back to a normal state of play is going to take a little time, both at the agency, at CIS, and at consulates. So right now, in the last 9 months, the EB-5 team, since all they had to work on were direct cases, and there weren't many of those being filed, so many of those resources have been refocused on different product lines. So they have to figure out how to get those same people back or train new people. So I agree with Brendan that adjudication-wise won't wait 60 days, but a switch is not going to be flipped. We're not going to start seeing approvals tomorrow.
Well, it's good to hear the confidence level there on speed. It remains frustrating for sure for our clients, and I'm sure most clients in the industry, about the uncertainty of the overall timing of progress through the EB-5 green card program. One of the things that LCR, and I know many others in the industry, had pushed for in the reauthorization efforts in Washington was to get a reauthorization that was lengthy, to maybe 10 years, maybe 8 years, but really trying to get it beyond the 6 or 7 year mark, because this is really what EB-5 investors have been dealing with. That the process isn't necessarily a 5-year process; it can be longer than that. And not wanting to see a reauthorization that really didn't give new investors the confidence that there would be a big upheaval and maybe program changes that really affect them. Brandon, how do you see this change to 5 years in terms of impacting investor confidence? How do you see grandfathering playing a role in that decision making?
Yeah, with the 5-year reauthorization and the grandfathering and the concurrent filing, I think this gives a massive boost of confidence to existing and potential EB-5 investors and the industry as a whole. With the so-called grandfathering provisions and the concurrent filing, in some ways, the processing times are not as relevant as they used to be, because the benefits of EB-5 can be accrued at a much earlier date than they could be in the past. So I think as an industry, we're very, very happy with these changes, because it gives us stability. I think one aspect of the so-called grandfathering provision that's been overlooked in our excitement is that as we know in EB-5, every time there's one of these program expiration deadlines, people who've been thinking about EB-5 and sitting on the fence for the past couple of years, call my office or Mitch's office 3 days before the program expires and says, hey, remember me from 2 years ago? I'm ready to file my 526 today. And that's still going to happen in September 2027. But now those people that do that, as the way the law is written now, grandfathering won't apply to them. So the last minute looky-loos, as we call them, in the future won't be able to take advantage of grandfathering unless the law changes. It only applies to those individuals who file their 526 on or before September 30th, 2026. And so I think that's actually helps the program integrity, because when you get close to these deadlines, people can't often get everything together. So you basically file filings that are at best skeletal, and it's a huge problem for USCIS to have to go back and ask the investor to effectively recreate, submit a proper filing at some point in the future. But overall, I'm very excited and very happy about these changes, and knowing that we have this program and we have the rules and regulation. Well, we're not regulations yet, but at least we know the framework for 5 years now, gives us a bit of stability and ongoing hope.
Yeah, all these gaps, especially the last one lasting 9 months, really spooked the market. Previously, there either have been very short gaps or no gaps at all, but needed reauthorization. So this just alleviates that whole concern now. But it's interesting, Brendan mentions skeletal applications. So there's always a balance there in putting together a skeletal application just to get in under a particular deadline. You want it, skeletal is okay, but it can't be frivolous, because the applicant has to be qualified and approvable upon filing. It doesn't have to be 100%. You may get an RFE and that's fine. But if the bones of the filing is determined to be frivolous for that reason, it could get denied. So folks like Brendan and I are always making that judgment call before we slap together a package.
I'm glad to hear that perspective on how this is very beneficial for investors. It's certainly the interpretation that LCR has, and certainly what we're going to take out to the market. And I think it will be very good and very exciting for investors to consider that new structure. The overall changes in the EB-5 program from the regulations, I'm excited about for a number of reasons, not the least of which is what I think is generally going to be an uplift in overall professionalism coming from the industry. This is a situation where the industry really hasn't had necessarily a level playing field. Firms like LCR and others, I think, had experience in other capital markets and basically governed their offerings in a manner that was essentially investment grade and would work under regulatory oversight. Others, didn't do that. This program reauthorization requires all participants to meet a meaningful high standard. I think that's good for investors, prospects, clients, in that there are going to be a more standardized transparency requirements and reporting requirements that I think are to the benefit of everyone in the industry. The requirement that these investments are going to be SEC regulated securities. Mitch, how do you see that impacting the marketplace? Do you see, or have you seen in the past, a wide range of differences between regional center offerings, and what do you expect to see in the months and years ahead with the new reauthorization requirements?
Well, it's certainly going to raise the game for all players in the ecosystem, all regional centers in the ecosystem. There has always been what we'll call tiers of regional centers, really serious, experienced players that have been doing much of this stuff anyway over time. I don't think any of the historic region or existing regional centers have been doing everything that's now required. But since everyone is going to be required to comply with all of these enhanced SEC requirements, I think we're going to see kind of a thinning out in the field. Some of the newer players, some of the smaller players are just going to leave the industry. It's just not going to be worth it to them because it's going to be a lot more expensive for them. They're going to have to engage on a much more lengthy relationship with Securities Counsel and Business Counsel and Business Structure Counsel, and record keeping requirements is just not what they initially thought they bargained for. So I think we're going to see a thinning out of like the second and third tier regional centers. The top tier ones that have been around for a while, and LCR is certainly one of them, I think it's going to be to their benefit. Most of the offering documents that we've seen from the serious players have all been high quality, and I don't think any of those are going to have a hard time complying with these new rules and regulations. They're much of the new elements have been complied with already, as I mentioned, and it's good that they have a 60-day lead time now to get their ducks in a row, and I think you and the others are going to be ready on that 61st day.
Well, we're certainly expecting to be, and I know others in the industry are working hard to do the same. Brandon, what are your thoughts about what Mitch said about a thinning of the industry, or do you also expect to see exits from the industry and retrenchment from more established players?
Yeah, I expect to see exits from the same tier of operators as Mitch does, the second and third tier, because of the requirements that Mitch mentions. And also, next October 1st, when regional centers have to get out their checkbook, and depending on how many investors they've had in the past year, write USCIS a check for either $10,000 or $20,000, and then a couple months later write another check for an I-924A compliant of $3,035. And if they haven't been active for a year or two, I mean, they're just throwing money down the drain. And I think they'll just, at that point, throw in the towel. Now, I know there has been some speculation in various quarters of the industry that some of the integrity measures and the changes in the target employment area rules will cause some of the established players, the so-called top tier, to exit the industry. I don't think that will happen so much. I mean, maybe one or two might exit the industry, but EB-5 capital has become an important part in many developers' capital stacks, and for various reasons. And so, okay, great. Maybe now you can't. It's more difficult for a project to do something in Midtown Manhattan, for example. But that same developer could do something in another area that qualifies as a TEA, and put their marketing heft and good market goodwill to use, and raise a bunch of money. So yeah, second and third tier, because of the expense and the overall headache relative to how much money they raise, yeah, I think many of them will drop out. But the top tier, not too many.
What do each of you think are the most significant integrity measures that affect regional centers going forward?
Oh gosh, I think the one's going to be the most difficult is the requirement for overseas agents to register with USCIS. I don't think that aspect of the law has sank in yet. I haven't started conversations with agents yet on this issue, but I imagine once they learn about it, there's going to be a huge level of resistance and probably significant efforts at evasion. So how can USCIS ever hope to police that? I think by the requirement for the regional centers and projects in their offering documents to list who they work with in terms of brokers, finders, and qualified referrals, and the fee amounts. And I think what they'll do is they'll compare a project's offering documents with their agent registry. And if someone's listed in the project's offering documents that didn't register with USCIS, I think there's going to be a problem. So effectively, Congress has turned you as the regional center deputized you to enforce that particular aspect of the EB-5 law. I think that's that's the integrity measure that's going to be, I mean, writing checks and having to go, regional center operators having to go and submit the fingerprints. Yeah, that might clear out some of the FBI cold case files, but, I think the aspect around broker dealer disclosure by the projects, their offering documents, and the registration process for overseas agents, that's going to be the most contentious issue, the most difficult one in that to manage.
Yeah, that's a sea change really in the psychology of sourcing investors right now. But I mean, by definition, an EB-5 investor is a sophisticated individual, and they realize whoever they're talking to in Delhi or Mumbai or Ho Chi Minh City, they realize that person's got to get paid by somebody somehow. So I think at the end of the day, as with all of these changes since 1990, the market will adjust and absorb it psychologically, emotionally. It's going to be a little tense and revealing to actually have it down on paper, but I think I think the investors are expecting it to be paid anyway, so it'll just be very transparent, who gets exactly what.
It's an interesting point in perspective. I'm wondering what you all think about from an investor's point of view, if they're investing with a project tied to a regional center that isn't meeting the new standards and expectations. What's the risk to the investor by tying in with somebody that's kind of playing outside of the rules?
Gosh, I think I'm not, Mitch and I are not securities counsel, so we'll tread lightly on this area. I just see a securities attorney just added something to the chat. Thank you for that, Michael. My sense is probably nothing much for the investor, but the investor, if they learn of these various things, maybe, just maybe, they could have an enhanced cause of action in securities litigation if they felt the need to. So I think it's more of a regional center issue and a finder, broker dealer issue than having an impact on the investor.
Good to know. Moving on to financing. This is an area of interest, I know, for a lot of clients and prospects in the past. Loans have been permitted in the past, but I think the specifics around it were a bit clouded. Mitch, can you talk a little bit about what those new provisions are? And, is the added clarity here really going to be a new opportunity for some set of investors?
Yeah, I didn't see much of a significant change there. More codifying existing practices. So loans are still good, gifts are still good. I didn't see anything prohibiting unsecured gifts, as we've been enjoying since the Zhang case of a few years ago. So I think all that's still good. Still prohibitions on redemption and certain debt arrangements of funds going into the project, but I didn't see anything too significant on that front. I don't know if Brandon has.
No, I agree with that, Mitch. It was more of a codification than any sea change.
Terrific. That's good to know. We're getting close to the top of the hour. We do have some Q&As, obviously from our group here. Let me move to those and see if we can't answer a few of them in the remaining minutes. One question from: what will be the sequence of processing of petitions now, fresh versus pending? Who's going to be in the lead here?
Should be pending. USCI, notwithstanding, the parts of the law that say that USCI should, quote, prioritize oral petitions. USCIS, not that they always do this, but they're supposed to process, EB-5 petitions on a first in, first out basis. So pending should be, should emerge before new ones.
I didn't see any, I agree, Brandon. I didn't see any changes in their adjudication priority in that they're only going to be looking at cases that are current at the agency for 526s.
Terrific. The question, how will the wait times be affected for investors who have already filed their I-485s and 526s since reauthorization of the program?
Well, we think that they're going to be, the agencies authorized to start adjudicating those now. So during this recent 9-month gap, nothing has been happening at the 526 stage, at the consular stage, at the NVC stage. The only things that have been happening are the ancillary applications on adjustment of status, i.e. work permits and advanced parole. So we've seen a few of those come out during the 9 months. But we think, our interpretation is that they're now authorized to adjudicate all of the above, but at a rate to be seen, as we discussed a little earlier.
Yeah, and I think that, overall, USCIS has been under a lot of pressure to, especially between now and September 30th, when the end of the current government fiscal year, to adjudicate as many 485s as possible, to use up as many visa numbers from the prior years that were not used because of the coronavirus. So I think that, again, at a pace to be determined, but I think we'll see, probably as a part of their overall I-485 adjustment status initiative, significant progress for EB-5 applicants who have had their 485s pending for some time now.
Thank you, Brandon. Thank you, Mitch. We have a project question. If a project submitted 526s prior to now, and they still qualify as a TEA project under the new law, and the only change is new investors will have to invest in at 800,000, can they submit new 526s, or must they file an exemplar within a 924 first?
Yeah, so this is one of the changes that, prior to yesterday, whether or not a project filed one of these so-called I-924 exemplar petitions was purely optional. Now it's a requirement going forward. And so, which is somewhat of a form over substance issue. I mean, because projects have to redo all for future investors have to redo all their offering documents and project documents, according to the new rules. And once you've gotten to that point, it's not that much, it's not that much more difficult to then submit the exemplar. So it just codifies that, what was kind of common practice to begin with. But yes, so any project that wishes to recruit EB-5 investors going forward now has to file an exemplar. So the issue of, if project A has investors under the old law but is still looking for additional investors under the new law, those prior investors are subject to the old law. So they don't have to invest additional capital and are not subject to new TEA rules. Only investors post March 15th, 2022 are subject to the new investment amounts, TEA rules, and any other rules associated with the new legislation.
And the application for that just needs to be filed. It doesn't have to be approved. So no one's going to have an approval for quite a while. So that's good.
Yeah.
Thank you. Another question around adjustment of status. If adjustment of status can be filed concurrently with the 526 petitions, does that mean that those in the US have an added advantage to processing times and visa allocation?
Well, they certainly have an advantage. Adjustment of status processing times can be as long as consular processing times waiting for an immigrant visa appointment. So that may not be the advantage, but the huge win, as we alluded to a little earlier, is the ability, once the EAD and advanced paroles are approved, that you can live and work and internationally travel here to your heart's content while you're in the AOS queue. So that's really huge.
And then, anyone who files a 485 prior to the age of 21, the age out issue is no longer relevant as well. So massive benefit. So, but yeah, with all the processing times, we'll just have to wait and see. But it's a huge advantage to be able to do concurrent regardless of the processing time balance.
It's helpful. Let's end on a question regarding a $900,000 investments. Well, we have folks in this category. I know others do as well. If one is applied in the 900K category, does the law provide for an expedited clearance?
No.
Agree.
Unfortunately.
Yeah.
What do you both see are going to be issues related to investors in that category?
I mean, there's not that many of them. I forget what the statistics were, like 135 maybe, if that many. So it's a very small elite group of investors that invest at the $900,000 level. I just think that, yeah, they'll just be processed in the same old first in, first out order. They're subject to the rules at the time that they filed. And, you know, might some of them wish to withdraw their existing 526 and, you know, refile at the lower investment, save $100,000 maybe? Does that really have any benefits? Probably not. So anyone thinking of doing that, again, consult with Immigration Counsel prior to undertaking such action. So, I mean, yeah, I think that the $900,000 investors are just, you know, victims of bad timing in terms of, you know, the Bearing case and now the $800,000 law.
Yeah, speaking of small groups of investors, a small group of lucky investors are the very small group that in the last 9 months got into direct enterprises, so to speak, at the 500K level.
Mm-hmm.
So that was a lucky cadre of people.
It was good timing for them, for sure. Mitch, Brandon, thank you for your time and expertise. I certainly found this session helpful. I believe those that are participating in the webinar did as well. Just to wrap up, I do want to say that at LCR, you know, we are very excited about the new elements under reauthorization that provide this going forward to be a safer environment for all investors. LCR has a division that is an SEC registered advisory firm. We are very comfortable in this kind of environment. We know others are as well. And we think we're going to be able to bring to market offerings that I think appeal to a broader set of folks with the kind of transparency and stability that the reauthorization provides. Thank you for LCR clients that are joining today. We certainly look forward to speaking with any and all of you in the very near future to answer additional questions that may not have been addressed in this webinar. And we hopefully will see you all in person as mobility improves in the coming weeks and months. Thank you, everyone.
Thank you.
Thank you.